If you are an MSP, if you are a break-fix company that thinks they're an MSP and you want to be in this business, in this profession for very long, I would get certified, because there is zero way that you are going to be effective in enabling this safe harbor for any of your customers if you yourself are not compliant with these frameworks. If you want to be compliant with any of these or all of these frameworks, UCS is the best starting point, because it will align you and your MSP business with all of the major global frameworks that exist. They will be specific MSP controls. They will be specifically applied to your business, and they will be specifically tested in a way that makes the most sense to your MSP practice. Then when you've gone through that, you will then be in an excellent position to be able to deliver those same controls downstream to your customers and help them check the box of any of these frameworks. On September 1, 2025, the managed services profession will receive a very significant boost in terms of their ability as MSPs to advocate for positive cybersecurity change amongst their customers. Why is September 1 so important? It's because that's the day when Texas Bill 2610 goes into effect and becomes officially a law. What the soon-to-be law will mean for MSPs and for their customers is so significant, not just for the state of Texas, but for all other states who are almost for a certainty going to be following Texas in what they've done. That this is going to be a game changer for the managed services profession. It's going to be a game changer for the United States in terms of helping smaller organizations become more cyber hygienic. And don't worry, if this is all sounding very complicated, stay tuned. You're at the MSPZone. This is what we do for a living here. We make MSP complex issues very simple to understand. And that's precisely what I aim to do today. So stay tuned. There's a lot here, right, folks? I've got my notes here are pretty lengthy about this topic. So I'm going to start slowly. I'm going to start from the beginning and talk through the evolution of this safe harbor law, explain what a safe harbor law is, and talk about the origination of this concept that we've been tracking for well over a year now. And that's probably the best place to start. The concept of managed services immunity started to get thrown around, right? If you've listened to this podcast for any amount of time, if you've seen us on social media, followed our writings, we've been talking about managed services immunity, or this concept that legislative bodies out there ought to be advancing legislation that protects the consumers of managed services, because MSPs are trying to help their customers become better stewards of data and IT infrastructure. And that type of behavior ought to be encouraged and promoted, the safe protection of IT infrastructure, that is. And if you have an MSP who is delivering true proactive managed services, then your chances of surviving a cyber attack are significantly higher. It doesn't always mean that you won't get attacked, but you certainly can dramatically reduce the number of successful attacks. And again, if you do happen to get attacked by some nefarious force out there and you have a true proactive managed service provider as a partner, then your chances, like I said, go significantly higher that you're going to be able to survive and quickly get back up on your feet. So that was the whole concept of managed services immunity. The bill started in the state legislature in Florida, and it was vetoed by the governor, not because they didn't want to pass it, but because they wanted some changes made to it. So it was vetoed and sent back, and basically a list of things that the governor wanted amended before he would feel comfortable signing it. Since then, we've been really pushing everybody that we talk to at a federal and a state level to get behind this concept of passing similar types of legislation. Now, the laws and the bills that are being promoted and are either being passed or are working their way through the legislative process don't always have the same name, so it's a little bit tricky. But I'm gonna fuse two names and two descriptive concepts together because they're, while not identical, they're following the same general direction and purpose, and that is immunity. Managed services immunity, cyber immunity, and safe harbor, cybersecurity, safe harbor specifically, right? Those concepts are very similar, and I'll explain why they're similar. It's because they are advancing this idea that if you behave in a certain way and you protect your IT assets and resources in a way that follows modern day best practice, you should be rewarded by having some protections against, for example, litigation or lawsuits if you were successfully brought into litigation, right? The concept still remains that if you are doing what you should be doing from a cyber standpoint, there should be protection. That's what a safe harbor law generally addresses. And that's what we had been talking about with this concept of cyber immunity or managed services immunity. Okay. That bill in Florida that almost got signed into law was kind of the kickoff of a fairly large state in the US really grabbing hold of this concept of, in order to promote and see real change, real cybersecurity change, at the smallest organizational level, you need to have some legislative action. We continue to believe that that's true here at MSP Alliance, and the state of Texas apparently was listening. Someone out there was listening, and they took our position paper. I'm not claiming credit for this publicly in terms of we didn't lobby for this or pay any money, I should say, to anybody to have this bill pushed. But we certainly were not quiet about it. And we certainly publicized heavily the position paper that the MSP Alliance wrote around managed services immunity legislation and the type of legislation that we thought would be necessary in order to see positive change. And I certainly believe if you look at this Texas bill that there is a very, very close similarity between our position paper and what is in that bill. The bill is not perfect. There are some things that I don't like about it. I'm going to talk briefly about those, but it's a good bill. It's a huge step in the right direction, and that's why this is such a momentous occasion, is because it's the second largest state by, if not by size, I think also by population. I think maybe Alaska is actually the largest by size, but anyway, that's beside the point. Texas is not a small state. Neither is Florida for that matter. So you have two states that are moving in a very similar direction. I would love to see California. I would love to see New York and others of similar size and population density follow suit. I'd like to see all 50 states follow this path in some way. And I think they will. But why I'm so excited and why I'm talking to you today on this episode about this concept is because Texas taking this momentous step of passing and signing into law a piece of legislation that will have a fairly dramatic impact on entities in the state of Texas, and the type of litigation and the type of damages that they would be subjected to is going to be absolutely affected. And I'll explain about that in just a moment. A little bit about the bill, Texas Bill 2610. What does it do? Let's just talk about that right now. The bill establishes a legal safe harbor for businesses that implement and maintain a compliant cybersecurity program. What does that mean? We'll talk about that and discuss that in a moment. It was signed officially into law. It goes into effect on September 1, 2025. The bill addresses a specific segment of the market. Now, this is one of my critiques of the bill, which is that it really it absolutely impacts and is addressing organizations of fewer than 250 employees that own or license data containing sensitive personal information. It's not the sensitive personal information restriction, it's the fact that they're only going after 250 user organizations. I would personally have no limit. It should be public and private entities of any size in the state of Texas. That's how I would write it. Why would I write it that way? Because the bad people out there don't discriminate and don't just target, users with only under 250 employees, right? They're going after organizations based off of opportunity and off of design, right? If they've got something that they want, or if they're just looking for organizations that are likely not going to have, certain cybersecurity defenses in place, that's where they're going to target. So I wouldn't restrict this bill in its application to only entities under 250 employees, but I'm not in politics, so that's not my call. But certainly that would be my suggestion, that somebody maybe revise that in the near future. Target of Texas Bill 2610: organizations in the state of Texas who handle or license or own data containing sensitive personal information, and organizations that have 250 or fewer employees. Okay. That's the target demographic here. The bill outlines specific requirements for businesses to qualify for this safe harbor protection. And I should mention what the protection is. The protection is protecting these organizations who are compliant with the law from being exposed to exemplary, or what we would normally call punitive, damages in breach-related litigation. There are some exceptions to this, right? We'll get into that in a moment. But what it is saying is, if you are involved in a breach and you are then sued civilly as a result of that breach, and you are accused of, among other things, right? You caused the breach. You caused my client or this party, the plaintiff, to experience harm, and we're going to come after you, and we're going to ask for these actual damages, but then we're going to go after you and say, we want punitive damages, penalty damages, which can often be significantly higher than the actual damages suffered by the parties involved. And that's where you get into, these very large judgments in a multitude of different cases, right? Not just, cyber, but you can get involved in massive punitive damages for any type of tort claims, slip and fall, personal injury, things of that nature. Don't want to give you a whole legal lesson here, but, punitive damages equals bad, equals big, equals something that you probably want to avoid if you can. And the Texas Safe Harbor Bill does exactly that. Now, how do you gain the protection of this punitive damages safe harbor protection? The bill categorizes or establishes 3 categories of organization, again, all under 250 employees. And it does it in a way that I can see why they're writing it this way. I can only hope that this is the precursor to evolutionary change, and this bill being updated in the very near future, I hope, where it would start to raise the bar a little bit higher, as you'll see shortly. So businesses with fewer than 20 employees must have a basic password policy and cybersecurity training. Those are the only 2 prescriptive things that a business or an organization with fewer than 20 employees in the state of Texas would have to demonstrate in order to gain protection from the safe harbor. Now, you may be saying, Charles, password policy and cybersecurity training, that's not really a lot. There's a ton more that we could be doing. There's MFA, there's backup, there's EDR, MDR, there's a long list of things that could be done. Vulnerability scanning, pen testing, etc. I agree with you. I think at some point this is going to have to be changed, but this is nevertheless what the bill currently states and calls for. Businesses or organizations with 20 to 99 employees must follow CIS Controls Implementation Group 1. CIS Group 1. I won't go through and read all of those controls, but they're significantly more involved than just having password policy and security awareness training. Businesses with 100 to 249 employees must implement full frameworks such as NIST, ISO, or similar. And in the bill, they list a long itemization of which frameworks. So in one regard, and one thing that I really like about this bill, soon to be law, is that it is not so narrow-minded that it says we're only going to follow one framework. It is listing a multitude of different frameworks to give maximum flexibility for the organizations impacted to be able to follow. I personally think that is a very wise idea. And if you are a legislator or policymaker for another legislative body in another state and you are listening to this program, I would implore you to follow that specific section of this Texas bill, because that's what you want to do. You don't want to be so rigid to say that there's only one framework that should be allowed. Those frameworks may, over time, become whittled down naturally. But I think for right now, it would be a shame to attempt that now, when we're just trying to get organizations that don't even know or care about cybersecurity hygiene to get active and become involved in making these changes. So I think the more frameworks, the better. And again, I understand why Texas made these kind of three groupings of business entity size and assigning different levels of cyber responsibility for each level. But again, if it was me and I was writing this, I would probably remove that. And even if you were just to keep this at 250 users or below, I would just make it all organizations would need to follow some sort of accepted modern cyber framework and use that as the baseline. I would do that because there's no reason to kind of lull a small organization into a false sense of all you have to do is manage your passwords and you're going to be fine, because that is not going to protect them from cyber attacks. That's not going to protect them from somebody who wants to get in there and do damage. And I'll break it to you right now. There are a lot of organizations that have less than 20 users that have very, very sensitive information, who right now today have far higher cybersecurity requirements put on them. And I'll give you one example right now, and probably countless in the state of Texas. And those would be defense industrial base vendors in the supply chain who sell into the Department of Defense. And to say to them, hey, you are a 15-person HVAC or engineering firm, and the state of Texas bill says you only have to worry about passwords and cybersecurity awareness training, but CMMC level 1 and level 2 set a completely different and higher bar, right? So that's the conflict that I would prefer to avoid. But again, I'm nitpicking, right? If you're in the Texas legislature and you're listening to this podcast, you did a good job, right? There's no two ways about it. You did a good job. This is a good bill. I'm just talking about how to make it even better. And I'm talking to other states that are looking at the Texas bill and saying, how could we emulate this and make this better? These are some just suggestions that I would recommend. So there you have it. You have a 3-tiered system of organizations, all under the range of 250 users or below. It does not discriminate or articulate the type of industry that you're in. It just says if you're 250 below, this safe harbor applies to you. And again, if you're trafficking in owning or licensing or managing, certain information that contains personal information, the protections for MSPs and customers of MSPs alike is significant. It's significant because this is the type of law that is going to finally give MSPs the authority to go to a customer who has been previously reluctant to invest in any type of significant cybersecurity resources and defenses. And it gives that MSP the ability to now talk to that customer in a way that is going to be meaningful and in a non-technical way, right? I can't think of something more powerful than to go to a managed services customer who has previously been just, you take care of everything, but I'm not going to invest in backing up my data. I'm not going to invest in MFA because it's a hassle. I'm not going to do EDR because I just don't see the value in it. But you, my MSP, are going to take responsibility for everything. Right? You all know about these types of customers. You probably have a few of them, is my guess. The conversation now is to the business owner, you are now on notice. The lawsuits, when they come, and they will come, when your organization is attacked and it's a successful attack, and it will come, a successful cyber attack will come on your organization, you are now going to be so far exposed in terms of punitive damages and the ability to really shut down your business, right? In a litigation moment where you failed to protect certain information and you just didn't do what was expected of you, you are going to have no place to hide. And we, the MSP, are not going to be there to take this on the chin for you. We're not going to save you from litigation. We're not going to save you from being sued into bankruptcy. We are not going to be able to protect you. We can protect you before the event happens if you do what we say and you listen to our recommendations, and we work together synergistically to create an effective cybersecurity program for your small business and help you protect yourself and protect yourself after breach from the nastiness of the lawsuit and a potentially very damaging business ending set of damages. That's a really different conversation than we think you ought to back up your data. It's only going to cost you this much per user, right? That's a technical conversation. Now, this is a business conversation. This is a business risk conversation, and it impacts everybody in the state under 250 users. That's a game changer, folks. That is a game changer. Now, personally, I'd love to see this impact every organization in the state of Texas, regardless of their size, because hackers, they don't care what size you are. They're going to get in because they want to get in. They want something that you have. But again, that's just my critique and recommendation for how to change and improve this law and other laws. It's going to change things for the MSPs who understand this law for what it is. And it's going to give them a tremendous amount of authority, and it's going to give them a tremendous amount of influence to be able to talk to customers and convince them about improving their cyber hygiene defenses. I will say this right now. I've been saying it for a long time. Break fix is dead. I've been saying that thing for a very, very long time. Folks, make no mistake about it. This law, Texas Bill 2610, soon to be law in September 1 of 2025. This leaves no protection for any customer in the state of Texas currently receiving reactive IT services from a provider, even if the provider calls themselves an MSP. If the services are actually just reactive, meaning that they're not really doing anything proactive, they're not really managing anything, they're just responding to bad things when they happen, you are going to have zero protection from this safe harbor law. You are left out there in the storm. Why do I say that? I say that because all of the frameworks that were listed in this Texas law are managed services frameworks. Let me rephrase that. They're not all managed services frameworks. There's only one managed services framework. That's the Unified Certification Standard for Cloud and Managed Service Providers, UCS. That's a managed services framework. CIS is not a managed services framework. It's a cyber framework. Same with ISO. Same with ISO 27001. Same with CMMC. These are not managed services frameworks. There's cyber frameworks, and they all actually kind of have different applications in practice, if not by design. So when I say a cyber framework can only be achieved through a managed services style of IT management, That's what I mean. And I also mean that you can't achieve compliance with any of those frameworks, managed services or just generically cyber frameworks. You can't achieve compliance with those frameworks as a break fix provider or as a recipient of break fix or reactive IT services. It's impossible. It's it's impossible. That's why I say the break fix provider is dead. In reality, are they going to continue? Of course they will. But it's my sincere hope that they listen to this podcast, read the Texas bill for themselves, and start to wake up today before it's too late and begin to change. And if they don't want to change and they just insist on being a break fix provider, then I hope that they either decide to leave this profession and do something else, or it's not my desire, but I think that there's a high likelihood that those types of companies are going to find themselves in litigation, and they're going to be presented with a business altering moment when they realize they messed up, they harmed or allowed harm to occur to a break fix customer of theirs, and they should probably be sued out of business. Now, that may seem like a harsh thing to say, but it's not like we haven't been saying this for 3 decades. Break fix is dead. There is no valid reason to have it anymore. And this law codifies it. To achieve safe harbor protection, you have to be implementing a cybersecurity program and cyber controls that can only be achieved through a managed services style relationship. Now, you either have an internal IT department, and here's a tip for you. Organizations under 250 employees, almost to a T, will not have an internal IT department capable enough to do this on their own, meaning they're almost all going to have MSPs at some level. Probably the vast majority of 250 user organizations and below are going to be using some sort of MSP, either full-time as their full IT staff or augmenting a skeleton internal IT team, depending on the scenarios. But MSPs are going to be involved, period. I would like to bring up another issue, which is how do you prove that you're in compliance with SB Texas Senate Bill? There are 2 ways that you can prove compliance. Number 1, you can wait until a breach happens and you can wait until the litigation happens, and then you can be in direct or cross-examination, and someone eventually is going to ask you all the related control questions of one of these frameworks, and they're going to start going down the list of, do you have a password policy? Do you have security awareness training? Is it active? Are you backing up your organization's data? Do you have vulnerability scanning or penetration testing at least once a year? Do you have any type of endpoint detection and software technology, EDR, MDR? Are you doing any type of identity-based detection response for user, access threats, and on and on? And if you do all those things, then you have just demonstrated in a legal proceeding that you are compliant. Well, if you're thinking to yourself, geez, that sounds like a really expensive way to ultimately have to prove that. And by the way, you're only proving that to one party, right? Your court transcript is not going to be the best piece of evidence that you're going to put on your marketing literature and give to your next prospective client and say, see, we were sued and we won, and here's all the evidence of what we did. And by the way, that's not going to prove anything. I mean, you're subject to perjury laws, sure, but I mean, it's not going to absolutely prove that you actually did these things. You're just saying you did under penalty of perjury. Which brings us to the second way that you can prove your compliance with a cybersecurity program or framework, and that's to get certified. That's why we've been saying for 3 decades, you have to get certified as an MSP. And now we've been talking about this concept of compliance as a service. Why do you think compliance as a service is becoming so red hot right now? Why is it so popular? Why are the leading MSPs are they all just, wake up one day and they all had the same idea at the same exact time? No, they're smart. Yes, they're mature. Yes, they're proactive. Yes, they are advanced from a maturity standpoint. But they all understand it because they're having customers who are coming to them saying, "You're not just our MSP. You can help us achieve and demonstrate compliance in a variety of different frameworks because we now have this need to demonstrate compliance to somebody downstream for us." Right? And so what do? They turn to their MSP and say, "Can you help us?" And the good MSPs say, "Of course we can." And the MSPs that haven't caught on to this, they're saying, I don't really know what you're talking about, but maybe you ought to go to, somebody else." That's not a good response. Being certified, being able to demonstrate, affirmatively demonstrate before anyone's even asked you, are you compliant with any of these approved frameworks? That's going to be the difference between the MSPs that are thriving and doing untold amounts of business, or the MSPs or MSP wannabes that are struggling, barely able to keep up, and not sure whether they're going to even be around next month. Which one do you want to be? What does this mean for the bigger picture? Texas is not the first state to do this. They're just, I think they have the best example of this type of cyber immunity or cyber safe harbor law, but they're not the first one. So Ohio had one actually back in 2018. They came out with one. It's a general business safe harbor law, kind of similar, and actually may have been the forerunner for all of this. But it is, I don't have the details on that other than it's applicable to general businesses, and it's does seem to align with major frameworks that are out there. Connecticut also has one, Utah has one, and Ohio. So Iowa. So Ohio, Connecticut, Utah, Iowa, and now Texas. Oklahoma has one, but it appears to be only applicable for hospitals, so medical. Tennessee has one, but only for private entities. And Oregon there's a question mark about Oregon. Looks like we have to get some more information to find out if they actually did pass something that's similar to what Texas did, but it appears that they may be on the list. New Jersey, Georgia, Illinois do not currently have a safe harbor law in place, but they are in proposal stage. So it has been drafted or it is being discussed, but it hasn't been signed into law. Florida and West Virginia both have proposals that were rejected or vetoed by their governors and sent back to the legislature to become improved in some way. But both of those states have already, followed Texas, and they're pursuing this actively. They're just trying to refine the language of their bills. So you have Ohio, Connecticut, Utah, Iowa, Oklahoma, Tennessee, Oregon, New Jersey, Georgia, Illinois, Florida, West Virginia. A good start, not close to half the states yet, but a good start of states that are geographically all over the place. Politically, this is not a political issue. This is do you believe in safe cyber hygiene or do you not? And do you want to change something about your state and its cyber defensive posture of your organizations? It's a good start. And I think having a large population and large geographical state like Texas, and we hope Florida will soon follow. I would love to see California follow this. I would love to see New York. I would love to see Pennsylvania. I would love to see, all the states, all 50 states need to follow one of these bills. And we're going to be putting up some amendments to our own legislative white paper, our position paper, to include some specifics of what we would like to see from new state safe harbor laws, as well as what we'd like to see from these existing laws like Texas, and maybe amend them in the future sessions. What's the takeaway? I've been talking now about this, and you're saying, okay, Charles, I hear what you're saying. I agree with you. What do we do? If you're in Texas, you go to the MSP Alliance website, you go look at the position paper. We have a link to the Texas bill there. You can go look at it for yourself, read it. It's not that big, one page, very easy to understand. And I would start with contacting all of my managed services customers, set up meetings, and I would start to say to them, again, this is if you're in Texas, let's talk about where you sit in this legislation, and let's make sure that you are protected with the safe harbor law, and let's design a plan. And at least for those who may be budget constrained, maybe they get it, but money is a factor. You can start to build into near-term budgets, a managed services plan that will integrate some of these security solutions in order to start to check off slowly at first, but very quickly, all or nearly all of the controls that are going to be necessary in order to be compliant with this safe harbor bill. If you are an MSP, if you are a break fix company that thinks they're an MSP, and you want to be in this business, in this profession for very long, I would get certified, because there is zero way that you are going to be effective in enabling this safe harbor for any of your customers if you yourself are not compliant with these frameworks. If you want to be compliant with any of these or all of these frameworks, the UCS is the best starting point, because it will align you and your MSP business with all of the major global frameworks that exist. They will be specific MSP controls. They will be specifically applied to your business, and they will be specifically tested in a way that makes the most sense to your MSP practice. Then when you've gone through that, you will then be in an excellent position to be able to deliver those same controls downstream to your customers and help them check the box of any of these frameworks. But if it was me, I'd probably start with CIS, Implementation Group 1. It's a really good starting point. And yes, we can help you do that, because again, your controls are going to be so critically important to a managed services customer of yours who wants to be aligned with CIS and get protection from this Texas safe harbor law, that when they come to you as an MSP and you say to them, we've already been tested, we've already been certified, now all we're going to do is we're going to align our controls with you and help you check the box and meet those controls yourself. You have now opened up a whole new level of deep relationship and trusted advisor status that it's going to put everything else that's come before it. It'll make it pale in comparison. This transcends tech. This transcends cybersecurity. This is at a deep level, you and MSP having a conversation and a relationship that is so fundamentally critical to that organization, and you helping them to achieve cybersecurity compliance and safe harbor protection. For those MSPs out there that are hearing this and it's making sense, you're going to be insulating your business for the next decade, if not more, by making these changes. If you're on the fence, if you don't understand what I'm talking about, if you're just not convinced that this is what I say it is, and you want to talk more, please reach out to us and we can book some time. I'm happy to talk to anybody about this. It's that important. You should talk to your customers. If you're not in the state of Texas, some of you may be saying, Charles, I don't live in Texas. I don't even want to go to Texas. I don't even have any customers in Texas. What should I do? I would still prepare for and probably start, because if you're not in Texas, but you live in Ohio, Connecticut, Utah, Iowa, Oklahoma, Tennessee, Oregon, New Jersey, Georgia, Illinois, Florida, or West Virginia, you either already have a safe harbor or you're soon to have a safe harbor. And if you're not in any one of those states, the same goes for you. It's a matter of time before this is going to become omnipresent in all 50 states. That's just my prediction. Now, there's going to be variations, yes, but I wouldn't hold back. I would still have conversations with all of your customers, because what's going to start to happen is court systems, as we litigate more and more of these situations, the protections in safe harbor states are going to soon make their way into contracts. And I should mention that the Texas and many of the other states that have passed these safe harbor laws, contract disputes, contract claims are not part of the safe harbor. Those are separate and handled differently than civil cases. So just letting you all know. But I think that these types of compliance cybersecurity program concepts are going to very quickly make their way into both managed services agreements, but also end user agreements or just general corporate agreements between end user companies and their customers, whoever they deal with. So be involved, talk to your customers. If you're in Texas, you now have this as a very, you have September 1 as the go live date. I'd be setting up meetings now. If you're outside of Texas, check the list. We'll post the list on the website at mspalliance.com. You can track that for yourself. But I would use this as a stepping stone right now for eventual passage of in your state or in multiple states. If you are like many MSPs and you handle customers in multiple states, it's gonna be pretty soon everywhere. Be prepared, be knowledgeable and aware of what this means. If you need help, we're here to help you at MSP Alliance. If you haven't been certified, get certified, and then you will be able to unlock the many opportunities of helping your downstream customers with these issues, because they're going to be turning to you pretty soon. And if your answer is no, I can't help you, they're going to turn to another MSP who can. And we don't want that to happen. I don't want that to happen. You don't want that to happen. So this is a good bit of news, folks. I'm really jazzed about it. This, by the way, came to us from one of our members in Texas. He said, "Hey, have you heard about this?" And I said, "Wow, I hadn't been following it that closely, since we had published our position paper. But it's good to see that there are some legislative bodies out there that are listening to this program, watching the MSP Alliance, and taking our advice and our recommendations. And for that, we're very thankful. And we hope that this is going to make some positive change happen. And like I said, nothing is going to happen at this level of 250 users or below without the MSP getting involved. This is a pro MSP bill. I would look at it very much as a pro MSP bill, and we'll keep monitoring it. You keep staying tuned, and we'll keep you informed of any changes as we see them. Until next time, stay safe.